So I will now call the case of 123-311, Mark Lewis Glasgow versus the state of Kansas.
Good morning, Your Honors. May it please the court, Morgan Kuhn for Mark Lewis Glasgow. Rather than belabor the facts of this case, since it's gone on for quite some time, I believe that this court is well versed in it. I want to focus on the issue related to Ms. Eckelman's representation of Mr. Glasgow at the Van Cleve hearing.
Before you get there, counsel, we really need to talk about the procedure
Certainly.
of this case, because issues about Ms. Ackerman that were in the 1507 motion had to do with the failure to bring the rest of judgment issues, and you've abandoned those.
Correct.
And after that, this case seems to me to be just a procedure. Because issues that you want to talk about here, you raised for the first time on appeal in the Court of Appeals.
Correct.
So the district courts never had a chance
Correct.
to look at this. And I read the briefs, you, to your credit, told the Court of Appeals you were raising these issues for the first time. The state's brief, to the way I read it, objected to it. The Court of Appeals didn't ignore that completely. And now we're here. And I want to know how those 5 issues that you want to talk about are fair game.
Certainly. So everything that you surmise is absolutely correct. And I think that at least in my looking at this case, when I received the case, the motion that was filed on the 1507 that was heard by the district court had some grounds in there to it, but in writing that and bringing that motion to the court, there was some tertiary discussion or raising of the issues of Ms. Eckelman in the Van Cleve hearing, but that was not really developed at that particular point in time. Once I started to get into the crux of it, then I went to go find whatever I could find in order to attempt to allow me to discuss the issue that I believed was the issue at hand, which is Ms. Eckelman's arguable abject failure to represent Mr. Glasgow at the Van Cleve hearing. She was involved in this case before sentencing, representing Mr. Glasgow at sentencing, filed a dispositional departure motion, raised some of these issues at that dispositional departure motion. Those were denied by the district court. Ultimately, Mr. Glasgow was sentenced, and then we get into the appellate process. So that's when I went in and I found cases, whether it be Strickland, whether it be Trotter, those types of cases where when you look at the utter failure of Ms. Eckelman, who honestly do anything other than cross-examine Mr. Podreberg in the Van Cleve hearing over the same issues that she claimed he didn't do, yet she had all this time to go do it, i.e. reissue subpoenas to the school and actually obtain the documents that those subpoenas were requesting, investigate whether or not the older daughter made allegations of abuse, so on and
We
so forth.
understand the 5 issues, but we sent an order out that wanted to make sure that you were prepared to tell us under Trotter how you could raise these issues for the first time on appeal within the 3 items that are set out in Trotter.
Because I believe that these particular instances and these particular items are so extraordinary in Ms. Eckelman's failure to address it. There's no issue that we have in this particular case regarding prong 1 of the 2-prong test. when we look at it, the state has already acquiesced that Ms. Eckelman's performance based on the totality of the circumstances was deficient and fell below an objective reasonable standard. They'd acquiesced to that in their brief.
Counsel, let me, okay, so under Trotter, unpreserved issues generally cannot be raised on the first time, for the first time on appeal, unless it only involves a question of law, okay, which arising on proved or admitted facts and is finally determinative of the case. Does that apply?
I believe that it does in this particular case, because I believe that the issue that we're dealing with here is really a matter of law, and that's whether or not Ms. Eckelman, who'd been in this case for quite some time, had the ability or didn't have the ability to prove prejudice. She says in the Van Cleve hearing, she didn't even know that she needed to prove prejudice. Arguably, she didn't know what the Strickland standard was.
Let me ask you about that. Look at Judge Hood's order from the Van Cleve hearing, stating that Eckelman was the lawyer on. Court only found deficient performance on the subpoena issue, full subpoena issue.
Correct.
All the rest of them, the court found no deficient performance. So for you to prevail on those 5 issues, if this is really a question of law, would mean that there would be that we would have to be able to just establish deficient performance when the Van Cleve court said there was no deficient performance of Podraberek. And that's not just a question of law. That requires the determination of facts and the application of facts in terms of what Ms. Eckerman could have done to overcome the trial court, the Van Cleve court's determination of no deficient performance. That's before you even get to prejudice. So I'm having really strong difficulty with your matter of law, but is that the only exception under Trotter that you've got? Let's start there.
Absolutely. I mean, for all candor with the court, that is the only exception that I have.
Well, I'm looking at this. What about 2? Resolution of the question is necessary to serve the ends of justice. And what about that?
Or
Well,
prevent the denial of a fundamental right?
I think that when you get into those 2 particular aspects of it, I think that when we look at what Podraberek didn't do in all of his investigation, and let me back up to address that aspect of it. So when we get into the several issues that the Van Cleve hearing was arguing, we don't have, well, Podraberek first said that he didn't even know what State versus Greg was and what it stood for. But secondly, from a Jackson v. Deno standpoint, he said he tried to claim it was a trial strategy, that he didn't find anything that where Mr. Glasgow made any incriminating statements. Yet Deputy Peralta says he didn't ask Mr. Glasgow anything, and Mr. Glasgow just starts to talk about whether or not the victim was sexually abused. So arguably those are issues that needed to come up within.
Can I just and clarify for me, what are you seeking here today? Your Van Cleve was summarily denied. Are you seeking a remand to have those issues heard? For us to reverse the summary denial and get back to trial? Tell us what you, and I don't want to interrupt the pathway here, but I'm trying to figure out, I don't want to go backwards, but what are you seeking?
Ultimately seeking another Van Cleve hearing. I don't believe that we can go any further behind the Van Cleve hearing, but
No, you can't get another Van Cleve hearing. That's the direct appeal process. What you're saying is you want us to remand the 1507 new issues back to the 1507 court to have an evidence to make the determination about a preliminary hearing or.
correct.
That's
Correct.
That's
Correct.
Okay.
Correct.
So as part of that, are you suggesting then that our standard of review, we treat the issues raised on appeal almost like a new motion? And so because the Court of Appeals then summarily denied, our review is de novo? Or are you suggesting that we still apply some sort of mixed standard of review because there was an evidentiary hearing, even though the district court never got to consider these issues? What is our standard of review?
Yes, I would like to say that the standard of review is de novo and the court can look at it and determine that the summary denial of the 1507 shouldn't have been done and remanded back for a hearing under the 1507. But I know that that also raises some issues because that particular motion isn't necessarily what was raised in the appeal. So then an attorney would have to be appointed, I guess, in my opinion, to represent Mr. Glasgow for an evidentiary hearing on this 1507. And then that particular motion would need to be amended and heard pursuant to the arguments that were raised on appeal.
Let me ask you a new twist. 1507 motions are statutorily prohibited to be successive. The fact that you're trying to raise new issues than the ones that were raised in the original motion, how is that not a violation of the successive motion program?
And the only thing that I can tell the court from that standpoint is the attempt to get around it under the extraordinary circumstances surrounding this.
I mean, the exceptional circumstances, extraordinary circumstances, those are issues in the ineffective assistance of counsel realm of things with the Van Cleve hearing, and that's not the animal that we've got here. Procedurally, we've got a 1507.
No, but if I go back to the 1507 motion, that's what I was arguing, I think, in my original brief, was that if you looked at it from a liberal construct, which we're supposed to do, that I believe that there was enough stated or enough alleged within the original motion as regards to Ms. Eckelman's performance under the ban. It just wasn't thoroughly vetted out through the district court's determination under the summary denial of that particular 1507 motion. So I don't believe that it is.
What's your case law support for that?
I have to go back and look that up. I don't know that.
And then the problem I've got with that is the 1507 motion itself. Paragraph numbers, I don't have it in front of me, but it said Attorney Eckelman has these problems, 1, 2, 3, and all three of them have to do with this effective complaint issue that you've indicated has no merit anyway. So
Correct.
when we're focused on Eckelman, which we have to be for this proceeding, we've only got three things in play. There are the itemized numbers in the motion. That's all the district court got to look at.
That's correct. That
So
is.
when you say there's enough floating around, I'm trying to figure out where it's floating.
Well, and that's why I say from the liberal construct, because the district court, this particular judge was the same judge that heard Van Cleve hearing, heard the trial, did all the sentencing, all of that. It was still Judge Hood that heard all of this stuff. So, and that's also, I guess, part of the problem. And I don't want to get into the theoretical aspect of it, but when we get into these 1507 motions, it's not like there's an attorney that's writing these 1507 motions for anybody that files them unless that person goes and hires their own attorney. And in this particular case, Mr. Glasgow did it himself without looking at the record or without having the mind that all of us in this room standing here have to look at the true issues that were the problem within the case. They're looking at something, or he's looking at something that he thinks he finds, but ultimately has no merit. But it's not to say that in this particular case, Ms. Eckelman's performance was, I guess, in Mr. Glasgow's opinion, in my opinion, downright horrible, given the time that she had within this particular case. She asked some questions and that was it. There was nothing else done. And she asked questions based on what she claimed was wrong, even though she had plenty of time to obtain the evidence to determine if it was in fact wrong.
And let me understand something along those lines. She was appointed, didn't understand that there was a prejudice prong that she needed to prove. And then the district court gave her time to brief that question and she never did that either.
Well, she did, but I wouldn't call it a brief. I mean, it was, and I saw that was, I mean, when I read that in the Court of Appeals' opinion, I didn't quite understand it. There was a brief that she filed. There was no, to my recollection, there was no case law cited. There was no argument made. It was asking.
Well, recognized, but nothing to back up the
There-
recognition.
Correct. There was a piece of paper file that said it was a brief. I would not call it a brief for purposes of what a true brief is. So
But the only I get back to the Van Cleve hearings findings, Van Cleve court's findings. And the deficient performance was on the subpoena to the school. So explain to me as a matter of law, how prejudice is established. Failure to follow up on the subpoena to the. What is it we know from the record that would show prejudice?
honestly, from the record, I don't believe that we know anything that would show prejudice.
You're just
based on-
saying if we get to go back and do it again, we might find something.
I'm saying that the prejudice is, and this is the difficulty of even getting there, just like you pointed out, is the prejudice itself is the fact that Eckelman didn't know that she had to show prejudice and she did nothing to show prejudice. We can't go back to the
I can't,
record.
but if you were doing this in a 1507 with an evidentiary hearing where that was the allegation, you could have developed in the motion facts to show why the failure to follow up on that subpoena was meaningful, as opposed to just saying, oh, there might be something there.
Yeah, and so that's where in my brief, I had worked it out to where if we were able to subpoena those records and those records did come back to show that the victim did make the allegations of physical abuse against Mr. Glasgow years before that were deemed to be unfounded, as Mr. Glasgow testified throughout the course of this entire case, then that documentation is allowed to be presented to the jury potentially in order to make a credibility determination of the complaining victim in this particular case, since the only thing that we had for evidence for the conviction of Mr. Glasgow was the victim's testimony. So at that particular point in time, we could potentially show significant prejudice to Mr. Glasgow because he doesn't have any, let's call them third-party documents to show that there were in fact separate allegations by the same individual that were deemed to be unfounded.
Or it could show nothing.
It could absolutely show nothing.
One final question. I just want to confirm that Eckelman was appointed, not retained.
I believe so. I don't know the true answer to that, but I believe that to be the case, but I'm not 100% certain.
Council, can I give you a new wrinkle? Hasn't been brought up yet.
I don't believe that I have a choice.
Back on
Your Honor.
the, fair enough, back on the procedural question. There are 5 new issues raised for the first time at the Court of Appeals, correct?
Correct.
The Court of Appeals didn't discuss invoking a prudential exception to hear them, but went ahead and reached the merits on those 5 new issues anyway.
Correct.
The court had a lot of questions for you about the application of Trotter and the 3 prudential exceptions for raising an issue for the first time on appeal. My question is, are we really applying Trotter here? Or are we actually reviewing the Court of Appeals application of Trotter? And there's a big difference between the two. If we're applying Trotter, it's sort of as a matter of first impression, and we're the ones that get to exercise discretion. But if we're actually reviewing the Court of Appeals, that's under an abuse of discretion standard.
Correct. And I guess I think that thinking through it, I think if we looked at it and we applied Trotter to the Court of Appeals and we looked at it from that abuse of discretion standard, I think that there's a high likelihood that the court just finds that the Court of Appeals didn't abuse its discretion in this case.
But that's what I'm asking you.
And so-
Is that what we're,
I guess,
let me put it this way more starkly. If the Court of Appeals, in its opinion, had said, well, we have Trotter and we have to decide whether it meets one of these 3 exceptions, and we so decide. We decide that it meets 1 and 2, let's just say. Then clearly our case law tells us we review that decision for an abuse of discretion.
and that,
But here the Court of Appeals just is silent. So what do we do with that?
and that's where I was headed next. And I was saying I would hope that this court would look at it as honestly like a case of first impression from this court's perspective and apply Trotter to the facts of this case. And
Want us to apply Trotter, even though that's a less favorable standard of review for you.
with all candor in this particular case, I don't know that I really have a favorable standard of review
Well, abuse of
but
discretion is a favorable standard of review for you, is it not?
It is, but I guess my question, I don't know that if the court looked at an abuse of discretion standard on what the Court of Appeals did, whether or not it would.
Let me just follow by. I know you're past your time, but sometimes when we get into this situation with a district court, there is essentially a rule that says courts are presumed to have made necessary findings, even if they don't articulate that in a written ruling. I don't know that we've ever done that with respect to our review of a Court of Appeals opinion. Should we?
I guess it's possible, but in this case, I don't know without truly thinking down that entire lineage, what ultimate benefit it would provide Mr. Glasgow as far as getting back to.
Well,
An
it all
evidentiary
comes
hearing.
down to that. Are we, is it an abuse of discretion standard, or is it essentially a de novo application of Trotter?
And I guess and thinking of it in those terms, I guess if we looked at it from the abuse of discretion standard from the Court of Appeals, if the Court of Appeals abused its discretion, if there was a way, I don't know, if there was a way to get it back to jury hearing aspect of it, then possibly, but without really, I didn't think of it in those terms, but without thinking through that aspect, I don't know that I can give you true thought out answer at this particular point.
Does it matter that the state did not cross petition?
So I thought of that this morning sitting in the hotel room, honestly. And and it was at about 7:45 when I thought of it. Other than having that thought that there was no cross petition on that preservation, again, I guess I would like to say that has been abandoned from the state's standpoint and the court could get to it, but again, without looking up any particular case law that this court's had at any point in time, I don't want to speak out of turn and say yay or nay in one way or the other. I think real quick and just summarizing based upon my brief, based upon the arguments contained in those briefs, Mr. Glasgow is requesting that this matter be remanded back for an evidentiary hearing based upon 1507 with the ability to amend it and argue the issues that were raised in the appeal. And I'll wait for my rebuttal time. Thank you.
Thank you, Mr. Fong.
May it please the court, Chris Alslager, Deputy Solicitor General, appearing on behalf of the state. And once again, this is another case where I've come into the case very late after all of the written documents were filed. So to use my tired baseball analogy, I'm again pitching in the ninth inning with runners already on base. But given I think the posture of the case, I don't think that's going to be an impediment. I mean, my first pitch has to be the procedural matter here that, as my opposing counsel really admits, these issues were unpreserved. They were not raised in the district court. And he's basically asking this court to remand the case to the district court for an evidentiary hearing on issues that he never raised in the district court, arguing it's necessary for him to do so in order to dig up the purported evidence that might exist, maybe to support his claims that he never raised. And it's simply inappropriate. We know the standard in a 1507 case is that a movement in a 1507 case is presumed to have listed all of his claims in the motion when he files it, and that any claims that are not listed are deemed waived and abandoned. And that is the case here. I mean, the court has already gone through the issues that he actually did raise, and then the 5 issues that the Court of Appeals addressed were raised in his brief, and he candidly admitted that in his brief. And you're correct, the state did object. I don't know why the Court of Appeals sort of skipped over that, but the matter remains. Those are unpreserved issues and should not be considered by the court.
Why do you get to make that argument?
Because that's the law.
Without cross appealing
Well,
under our precedent, I guess.
because the lack of preservation remains. I mean, he abandoned these issues at the outset, at the beginning, at the get-go, when he did not raise them to the 1507 court. So the issues were never properly before the court. Now,
Well, but they were raised, the Court of Appeals. But I mean, the state argued procedural default and substantive responses to the new issues raised on appeal. Court of Appeals either implicitly found an exception or didn't address it, but now we have a ruling on the merits and a cross petition that doesn't preserve the procedural argument that the state raised before the Court of Appeals. So
well,
how do we get, is there an exception or an angle around our existing precedent?
well, I would say if you ignore, I mean, if you go down that road, you got a couple of issues. One is practical and one's kind of paradoxical. The practical issue is that if you go ahead and review the issues on the merits, you have the same problem you already identified. These are issues of mixed law and fact, and you have no facts from the district court. So you end up eventually going down the same road that the Court of Appeals did. You know, you'll have to come to the conclusion that there's no factual support to find prejudice, which is fine with me. I mean, the state should win. The paradoxical problem with it, and I did kind of kick this over my head, is that, okay, if you hold the state to a waiver, but then you're excusing his prior waiver. So, you know, he waived first in time, or he abandoned first in time. So why is it okay to excuse that later on in the proceedings? Because the state, you know, got a favorable opinion from the Court of Appeals and didn't cross petition. I mean, that is another issue with when it comes to cross petitions and so on, is when the state wins, you know, the statute says that you can petition for review when you've been aggrieved by the Court of Appeals, but the state wasn't aggrieved. We won. And I ran into this cul-de-sac once before in a prior case years ago, and was told by this court that you weren't aggrieved, so you don't get to petition for review. So
The issue cross petition for review, you know, the conditional cross petition for review, you could easily say, if you guys are going to take this, then we want to chase down this road. So that's the procedural posture. And, you know, and the problem I'm having, waiver thing, you know, I wish it hadn't happened, but typically when the Court of Appeals properly considers unpreserved issues and says, this is the exception we're going to invoke, that's the ruling, and the state doesn't cross petition for review, we skip over it. We don't relive the preservation question anymore, you know, and go on. You know, so, okay, with that, what do we do with this?
I suppose if the Court of Appeals had actually done the analysis and given you a decision to review on the procedural matter, then maybe it would have tipped the state to the county attorney to cross petition. I think part of the problem is that the Court of Appeals just skipped it entirely and didn't give us any. There's no decision to review. I don't
know which exception,
or if they
invoked,
or if they applied any exception. I mean, that's the problem. Is somebody had asked about the
you
standard.
if you assume decision on the preservation issue, you still don't know which of the exceptions were triggered.
Yeah, that's like somebody had asked a question about a standard. I mean, what is the standard of review on a decision that didn't happen? I mean, how do you review a non-decision? And this goes.
What do you mean that it didn't happen? I mean,
well, how do
they reached the merits?
They reached the merits, but they didn't give us a decision on the preservation issue.
Isn't reaching the merits in a decision?
It is. I mean, it's implicitly, they skipped over the.
Yeah, they don't articulate which exception they're invoking.
Exactly,
but does that mean that?
Well, we don't know what it means, honestly. I mean, as a practical, I mean, what we do is, as you said, we presume that they jumped over it or that they decided it, but we don't know what they decided. We don't know what exception they used, so there's no decision to review. So I think you're kind of stuck back in, you know, de novo review of Trotter if you want to, you know, to look at.
Why isn't that still an abuse of discretion review?
Well, it could be. I mean,
let's just assume, for purpose of my question, that it is an abuse of discretion review. How would you articulate the state's position that the Court of Appeals abused discretion in reaching the merits of these issues?
Well, there's two options. I mean, one, by simply failing to address the issue, the court abused its discretion. It made a mistake, and I would say made a mistake of law. Either way, I think it made a mistake of law then by not applying the three exceptions or giving us an answer on the three exceptions. So I think you get right back. Either way, I think you get back to the same point. You got to look at the Trotter exceptions and you look at it. This case doesn't meet any of those exceptions. I mean, it's not a question of law. This is, I mean, courts said over and over and over again, ineffective assistance of counsel claims are mixed questions of law and fact. We know that. I mean, you have to have facts. So it doesn't meet the first exception. This is not a question of law.
Does Trotter set forth a legal test, a bright line, like the switch is either on or off? Because other places we say that these decisions to hear a matter for the first time on appeal are prudential.
Yes, it is. It is a potential rule. Absolutely.
So if it's prudential, then it's not an on-off switch.
Yeah, you're correct. I mean,
Should we remand to the Court of Appeals to apply Trotter and exercise their prudential judgment?
you could do that. And I don't know if, I mean, that's one option. You could also simply apply Trotter yourselves. That's, I think, within your discretion to decide how to handle that. I think you can look at this though and easily decide that none of the Trotter exceptions
Well,
apply.
explain to me why exception 2 doesn't apply. And I'm thinking of the denial of fundamental rights. While you don't have a right to counsel at the Van Cleve stage, once counsel is appointed, don't you have the right to have competent counsel? Clearly, there's been deficient performance at both the trial level and at the appellate level. And why isn't that a denial of fundamental rights?
Well, I would say it doesn't meet the fundamental right exception because he's had his opportunities and he's asking for essentially a third bite at the apple to go on a fishing expedition.
No, he's had his opportunity through counsel who's been deficient at both trial and at the appellate level.
And he had the opportunity in the 1507 motion to raise those same issues and he didn't. And he knew, I mean, he was present at the trial and he was present at the 1507 hearing. And, you know, the whole issue of the subpoena of the school records was brought up then. He knew he could have put that in the 1507, but he didn't. So I would say he's had his opportunities. This is not a denial of a fundamental right or the ends of justice to me seems to be, you know, an extraordinary situation. Perhaps, you know, when you're looking at somebody where you scratch your head and go, this could be an innocent man, but that's not what we're dealing with here. I mean, this is an issue where he wants to go on a fishing expedition for items that may not even exist. And that's what the Court of Appeals came to the conclusion is that there's nothing in the record to ever indicate that these supposed records even exist. And in fact, the record evidence it really suggests that there are no such records. And that's why he could never get to prejudice.
Aren't you going past what counsel did in order to get?
What do you
Talk
mean?
about the records. You have to get through what counsel didn't do. I mean, if counsel who was supposed to do all of those things, perform that fishing expedition, if you will, it's their performance, not whether or not the records show what they might show.
Well, yes, but but there's two pieces of this. He should have raised that performance issue in the 1507. He knew about it.
But
He
what if
didn't raise
didn't?
it.
Because he had inefficient counsel.
No, the argument that his counsel was defective for not subpoenaing the records was known to him before he filed his 1507. That was argued at the Van Cleve hearing. So if he wants to argue that Eckelben was ineffective for not subpoenaing those records, well, he could have raised that in the 1507, but he didn't. He raised 3 other issues. Therefore, it's abandoned, it's waived. He's just asking for another bite at the apple.
Eventually, he had counsel at every single step, right?
Yes, yeah, I mean, when he got to this level, yes.
So if his counsel didn't raise the issues that should have been raised, and that keeps multiplying,
Well,
what effect does that have, if any?
I think we've had two counsel, okay? The first counsel was the one piece of deficient performance where he was found to have performed objectively unreasonably was his failure to subpoena these records, which we don't know whether they exist or not. The second claim, which was not raised in the 1507, was raised in his appeal below at the Court of Appeals for the first time, is that his Van Cleve counsel was ineffective for failing to subpoena those records to establish prejudice. Okay, now that was decided before the 1507. So, I mean, he knew about the failure to get the records, or to seek the records. They're nested one on top of the other, but he knew about them. He could have raised those in the 1507. He did not. The claim is abandoned and waived. Now the Court of Appeals skipped over that and just went to the record and said, well, you know, and relying on the standard, you know, in 1507 case law says that conclusory claims aren't enough. You have to provide some factual evidentiary support for your claims to get an evidentiary hearing. And again, he didn't do that because there was nothing in the record to indicate that these records actually exist.
But to Justice Rosen's question though, and I don't know if we're possibly talking past each other, but he was getting to the second exception under. And we understand all of these things weren't raised. What I'm trying to get to is, does it matter that they weren't raised by multiple?
Or Mr. Glasgow himself when he submitted the 1507. Yeah, the point is he's saying his justice requires him to get a second bite at the apple that he's already, or really a third bite at the apple. And I'm saying that no, I mean, at some point the perpetual motion machine has to stop.
So you're saying pro se personally, he should have overridden all of the decisions that he depended on his counsel to make at all these successive steps?
No, there's no overriding. I'm saying he was on notice that he could have made this claim in the 1507 if he wanted to claim that Eckelman was ineffective for failing, because he was aware of it. Everybody was aware of this was one particular issue, and he didn't raise it in the 1507. Now, he didn't overrule any counsel. He didn't override any counsel. He just decided not to claim that his Van Cleve counsel was ineffective for failing to do the very thing that his trial counsel was found deficient for. And so now he, realizing his mistake, he wants to go back and get a do-over. And that's not fundamental justice. That's just him trying to get around the procedural rules to get a do-over. And we don't do that. And then my other point on this is that, as I was kind of getting to, is that if you do go back down this road, then you end up in the same position as the Court of Appeals, which looked at the record and there's no evidence that these records ever existed. He himself testified that he never talked to the school about it. He has no actual knowledge that any records exist. He just said that he heard from his other daughter, KJ, that this happened. So he's relying on hearsay upon hearsay that these supposed records exist, and that's not enough to support a claim in a 1507 motion. Even if he had raised it initially, it's a conclusory argument. He would have to present some kind of evidentiary support for it, either some kind of assertion of his personal knowledge of it, or some, maybe an affidavit from his daughter that said she had something that would say there's evidentiary support for this,
Yes.
regardless of the preservation issue.
So the state would like our court to find that the new issues were procedurally defaulted. I just want to play that out a little bit in terms of what that means for Mr. Glasgow down the road. Could he file a new 1507 with the district court raising these new issues? Certainly, I'm not talking about, whether that's successive or not. Maybe they argue exceptions to successive or whatever time limitations, but does the state believe, if this court's holding, I'm not suggesting it would be, but under your argument of procedural default, what happens to the substantive Court of Appeals ruling in those circumstances? In other words, would the state believe that successive motion with the district court would be barred by res judicata or claim preclusion because of the Court of Appeals decision? Or under your remedy to find a procedural default here, does that sort of undo the substantive, so you no longer have a ruling on the merits? Does that question make sense to you?
Yes, I think the claims are procedurally defaulted. They're defaulted. If he tries to raise it again, they're still defaulted. I think actually the Court of Appeals erred really in getting to the merits.
But why are they defaulted? Are they defaulted?
Because he didn't raise them in his 1507 motion in the first place. As I quoted earlier on in my discussion here, the case law is clear on 1507s. When a petitioner or when a movement files a 1507 motion, he is presumed to have listed all the claims that he intends to raise, and that any claims that could have been included that were not are deemed waived and abandoned. They were waived and abandoned and defaulted at that point in time. Once-
Isn't the state's position, which you just articulated very clearly, that the Court of Appeals erred? Isn't that exactly why we have rules requiring a cross petition?
Yes. Okay. I mean, it's the ninth inning. I have runners on. I mean, I'm stuck with the lack of a cross petition. That being the case, that doesn't change the fact that the initial waiver happened at the trial court level, and we shouldn't even be here. We should have never got this far.
Can I follow up on Justice Wall's question? So what you're saying is the Court of Appeals decision that I have right here, would that address these 5 issues would become res judicata for him raising them again?
No, I think that
Did I misunderstand?
No, the raised judicata, or the procedural default lasts forever. I mean, he failed to raise them in his first 1507, had the Court of Appeals never addressed the merits, it wouldn't matter. If he tried to raise them again, after the first, in a second or successive, third, fourth, whatever, 1507, they should be defaulted because he could have raised them before. It's the rule is the rule. And that's what I'm saying. I mean, I'm not saying that the merits decision by the Court of Appeals is res judicata. I'm saying that the procedural default.
Okay,
Yes.
I wanted to, thank you.
He can't raise them. He can't file another 1507 because of the procedural rules barring successive 1507s. Are no further questions, I would conclude my argument and ask the court to affirm the district court.
Thank you. I don't know that I have necessarily anything to add other than within the 3 prongs of Trotter, within the 3 aspects, they don't have to all be there. It can be just one because it's separated by the or. So look to the second one, we could get to the issues that we've raised here in this particular. I guess in Mr. Glasgow's opinion, in our opinion, correct the errors that were perpetrated on Mr. Glasgow by Ms. Eckelman's complete failure. It's in our opinion, represent him whatsoever at the Van Cleve hearing and get aspect of relief that Mr. Glasgow when he was being represented by counsel.
Let me ask you about the point made by the state concerning Mr. Glasgow's presence at the Van Cleve hearing so that he would have known exactly what happened and what didn't happen in relation to the subpoena and presumably the other 4 issues that you talked about, and then still failed to raise it in the 1507. Now, first thought that comes to mind is we a little more lenient with pro se parties, but this is a guy who knew to argue in the 1507 motion about arrest of judgments, defective complaints, defective jury instructions. All those are in this 1507 motion. But now all of a sudden, knowing all of those more sophisticated things, he still doesn't come in and say, and oh, by the way, they didn't pursue the school records.
Interesting question. So again, not in any of the record, and I guess we're gonna have this conversation because it's brought up. So I've met with Mr. Glasgow several times. I would find it very difficult to believe that Mr. Glasgow drafted that motion himself. In my dealings with Mr. Glasgow is not an individual who is sophisticated enough to raise the issues as you pointed out, Justice Wiles, to the extent that he raised them in his motion. In my dealings with Mr. Glasgow and the correspondence that I have had with him, mentally not there, which is why when I looked at the 1507 motion, when I looked at the summary denial of the 1507 by Judge Hood, arguably the one and only argument that I had to attempt to even get to this point for Mr. Glasgow was the argument that I made, which is why I made it in arguing that there were enough exceptions in order to have it heard on the merits and get Mr. Glasgow an evidentiary hearing on this 15. Because ultimately, Ms. Eckelman failed him, Mr. Poderberg failed him. There was an attorney present. Not certain that anything was actually done to represent Mr. Glasgow other than some cross-examination of some witnesses when you arguably had the opportunity to challenge the credibility and the veracity of the witnesses against Mr. But I think that that's also one of the issues that in my practice, I've been on both sides of the 1507 motion. Some instances, the 1507 motion is drafted properly and the court's able to hear it and address everything. In this particular case, it was a convoluted 1507 motion where there's things in there that raised beyond me why they were raised, other than someone somewhere who was drafting this motion thought that it was a good thing to put it in there. No real meat behind any of those particular arguments. I think also gets us to the issue that we have, which is I think where Justice Wilson was going, which is when we get to the looking at the ends of justice exception in Trotter. Butcher Barrett didn't do what he needed to do. Eckelman certainly didn't do what she needed to do. But we've got the record that we have. I can't stand up here and say that there's anything within any of the documents that would be able to be ascertained that would prove anything different than what we already know today. The only thing that I do know is that particularly Ms. Eckelman absolutely did represent Mr. Glasgow arguably at all in this particular case. So again, if there's no questions based on the briefs, we would ask that this to the district court for an evidentiary hearing. Thank you.
Thank you to both counsel for your arguments this morning. The court will take this appeal under advisement.